All right, everyone, we have the normal Tuesday meeting now of House Judiciary. We've got 6 items on the agenda. I'm going to call out to see who is here. Representative Mitchell, not here yet. Representative Benton, not here yet. Chairman Knight, I think I see you. Your smiling face. Well, you're the lucky man. Please, you can bring somebody with you.
Yes, sir. Thank you.
We're going to first hear HB 291, and we're working off LC 362268. And Chairman Knight, you're going to be presenting the bill.
All right, Mr. Chairman. I got my copy. There it is. All the stuff in order. Mr. Chairman, thank you. Members of the committee and Ways and Means. I thought Ways and Means was a hard committee, but this one's.
This is a fun committee.
It is fun. It's a learning committee, Mr. Chairman. And first of all, I do want to say thank you. I see Sean Marie Story in here, and I don't see Jill, but Mr. Chairman, as you're probably aware of, we've held, this will probably be the 5th hearing on this bill. We started over the interim with Chairman Powell, and
last year.
Yes, sir. And we've had a lot of vetting of this bill, and I want to thank Sean Marie and Jill for their work on this. As we got into this,
remember, time is of the essence.
Yeah. Well, as we got into it, they helped a lot of the drafting issues, and I think this is what I'll say with the committee. A lot of the issues that we found in here that you're going to see are actually definitional changes that legal counsel helped us shore up over decades of changes. The force of the bill, Mr. Chairman, is in lines 1 through 17, which basically provides that we're moving the State Board of Accountancy from the Secretary of State into the Division of the State Accounting Office.
And that is primarily the certified public accountants of our state as a professional body.
Yes, sir. That is it, Mr. Chairman.
Okay, of which you are a
member. I am a CPA.
All right.
A going broke CPA, not being able to do many tax returns this time of year, but I am one of them.
All right.
So,
and Representative Powell was the chair of the subcommittee last year, and what committee to come out of this year? We have new chairs.
I believe that was Chairman Fleming's committee, sir.
Why don't you tell us about your work on it, Mr. Fleming? And
Mr. Chairman, I was about to tell you that I had to go present a bill in another committee during this discussion, and Representative Powell handled it in the subcommittee, so I apologize. I was not there for any of the discussion.
No problem. You don't have your folder, or the bill's not in the folder? We'll get you one. Get out another. Get out. Whoops.
I think you read the wrong one.
That's
Did I real?
5915S.
My mistake. Let's see. I read on here what they had, which was
We got the sub after this.
Okay, my mistake. Reading off my sheet. It's actually 295915S. My apologies. I was using our sheet here, the memorandum, which was wrong. My mistake. So, the main thrust of this is to still have oversight of accountants for disciplinary purposes if there's something they do improperly outside the standards, in violation of law, whatever may occur as far as their conduct and their practice as a profession. But it now will be in a different setting other than the Secretary of State's office. It will be the Georgia State Board of Accountancy, correct?
Well, it would be under the state accounting offices, which we're moving it to.
Okay.
And as you know, Mr. Chairman, that that office is made up of CPAs, the directors of CPA, and we believe that the proper oversight, having someone who understands the profession, understands our standards, will help make sure that from an organizational point of view that we are set up properly and have the resources from a perspective of knowledgeable people about our profession. Likewise, like the bar, you've got attorneys that are helping are in the background. So that's the impetus.
But as I read, the the oversight group will be the State Board of Accountants.
Yes, sir. Yes, sir.
So that's where you now will have oversight of those who are members of the Society of Public Accountants.
Yes, sir.
Correct?
Yes.
Okay. Any questions of the presenter? We do have questions. I think yours is first. Mr. Weldon?
Thank you, Mr. Chairman.
I got you right, number 7 there, right? Just can't hear you. Go ahead.
Thank you, Mr. Chairman. Chairman Knight, the Secretary of State, I think, not with you. Would you agree with that?
I would say that's a true statement.
Did this bill go through the court process?
It hasn't, and that's one of the reasons we're going to continue until we have a bill that tells what we're doing. We're moving this process along, and we can't go through a court process unless we've got something in order to let court review what we're doing, how it's being done.
Well, let me suggest to you, I had a bill, House Bill 301, went through the court process, and they said, we don't need this, but Secretary of State told us pretty close to the same thing they told you, and they spoke against the bill and all that, and I would hate for you to be running up against the same issues I ran up against in bringing my bill, because the bill I took was to require roofers to be licensed, and that's one of the biggest complaints we have in the state.
Well, and I appreciate, Mr. Chairman, those words, and certainly we've thought about this, but we've been working on this for over 2 sessions. We're continuing to plow along, and again, I know there's other situations out there, roofers and other of the professions, but this is one I think we all got to plow our own road and look at it individually from a perspective of each individual industry or profession. And that's what we're doing. So
let's trust the will of the General Assembly may carry some weight on that point, hopefully. Mr. Caldwell, was it yours?
No.
Okay, I'm sorry. Ms. Oliver, I beg your pardon.
Mr. Knight, I'm going to vote for your bill, but I've been confused this appropriation session. Dr. Hawkins trying to explain why we're putting more money into the dentist and the pharmacy board from the budget, and I never really understood that argument. Do you anticipate you having a appropriations bump next year, and are you raising your dues?
Well, I think our membership, we polled our membership. Our membership is willing, if it should come to that, and that's one of the things we did before we start this, to raise our dues. Should that be necessary.
But you haven't done it yet.
We haven't done it yet.
I just remember your dues were only $25 a year, and I remember thinking that was kind of low, but I just wanted to
50. Is it 50?
every 2 years.
50 every, yep.
So $25 a year, and I'm just telling you that this became a problem in our appropriations process this year when the dentist and the other board cost us $1.4 million, and I didn't know whether it was your dues money, but I'm just giving you that.
I don't think it's an issue of the dues money. I mean, what we found in our profession going over this is that basically we're a huge donor. Even at that low amount of money, we're a huge donor, and so but we
all right. Mr. Fleming.
Mr. Chairman, thank you for coming today and bringing your bill. I know that you've been talking about this for a little while, and I remember it last year, and then I apologize, unfortunately, because of our schedule. I had to go to another committee and present a bill. At the time, Chairman Powell handled this for you in subcommittee. Normally I would have been there and had gotten my questions answered then. And I was going to ask a question very similar to what Representative Oliver was asking. We have a hand-signed note here from the Secretary of State. I don't know if you've seen this.
No, I have not seen.
Yeah,
I'll tell you what.
And I'm a great admirer of our Secretary of State. I think he does a good job, and I know he has difficulty with budgets like everybody else does, but I'm trying to reconcile my desire to want to help you with this bill, and I know you have worked on it hard, and also try to do what I can to help my Secretary of State when he asks for our help. And I guess the main issue I see him talking about in this letter is the funding. where is
You
the
know,
money
let-
going to come from to run this new different kind of agency we're going to have?
Let me tell you. Let's get down to the root bar here. The bottom line is that we're a donor. The bottom line is that the organizational structure of our profession, and I do say profession with respect to a lot of the other things that we're dealing with, roofers and things, is that the organizational structure that we have no input. We're assigned a director. We have directors that are moving on, and I think the equivalents, we had some statistics. I'm sorry I didn't know to bring this to detail, but basically we got about 0.55 of a staff assigned to us. And when I have board members that come up to me and say, you know, we've requested items on the agenda and basically being told by the Secretary of State, no, we're not going to do that. That is not what my profession, and I don't think that the people of Georgia who are relying in every sense of a financial decision they make, from the attestation function that we provide to almost all the businesses or the bigger businesses, banking institutions, government, you know, we're in a position where people have to have faith that the attestation function and we as the CPAs are doing our job, and we're held to the training standard or the educational standards that we have here. This move is not about the money. It's about putting it in a place where we've got a CPA who's in that branch who is going to be able to understand our profession and make sure that the resources that we have are used to the fullest extent that they are. That we get a CPA or somebody, an executive director who is going to
Actually, is the CPA?
Mr. Chairman, you just nailed it. That's the bottom line of what we have here, folks. Our financial industry depends on us, and that's why we're moving. So, again,
Mr. Chairman, I'm with you on all that. That's why I'm very sympathetic to the situation you have. And I remember in these discussions last year at one point, somebody with the organization asking and making a very valid point. They said, look, you're an attorney. You have your own bar association. You know, you can you imagine if you had to do X, Y, and Z? And I said, I agree. You're a professional. I don't argue with that. I said, but what are your dues? And they said $25 a year. I said, mine's $300, $400, $500 a year.
Well,
that I pay. So my
yeah,
question is, I'm trying to when I see the Secretary of State, I'm trying to tell him what I'm going to tell him when I act on this bill. Is your organization committing to raise their dues to a sufficient amount to cover all the money it's going to take to run this?
Absolutely. Well, I actually told the Georgia Society of CPAs to poll our members. And
so you're basically giving us a
the
guarantee they're not going to come to the Appropriations Committee and ask for the more money that the Secretary of State says that he's worried about.
No. In fact, you know, our dues are low. But if y'all read the law behind all this stuff, basically, you know, there's also the dues are supposed to be approximate of what the services are that are provided. And so even at the low level that we are, you know, we're a big donor. We're barely getting it out. And right now, our applicants to the CPA exam, we actually contract through the national NASBA, National Association of State Boards of Accountancy, and the applicants pay the fees to go through and do that stuff. Basically, the Secretary of State is doing renewals for us, and that's it.
Thank you.
Did Mr. Fleming, did the Secretary of State provide a written letter to you?
You too, Mr. Chairman. You
I
said
never
open
saw
it
one.
yet.
I never got one.
Is in that stack right there?
I've always had problems. Not always, but did he also advise you when he was going to close down the archives last year?
He didn't consult me on that, Mr. Chairman.
He didn't consult any of us. I don't
Mr.
believe
Chairman,
on
let me
that.
also make
go
a
ahead.
point.
Yes, sir.
That, you know, talking about the Georgia Composite Medical Board, aren't they independent?
Sounds like I didn't get one.
Aren't they independent?
Well, here's this one. Here we go. All right.
It was under his folder.
Excuse me. All right. We've got one other question, Chairman Knight.
Yes, sir, Mr. Chairman.
Yes, sir, Mr.
Yeah, thank you, Mr. Chairman.
Rutledge.
The felony thing, is that still in here? You know, where
Representative,
I can't find
me
it.
to the
I'm looking, I don't remember, but it just, you know, it just doesn't sound good. You know, that a board can make a determination if a person has a felony that the board may revoke their license to.
And again, that was, you know, in conjunction with Jill, you know, from legal counsel. you know, I'm not sure. I think that's permissive. I will assure you that our board is not going to allow someone with a type of a felony that would not uphold a high character. But again, when we wrote this, and with many meetings with legal counsel, that was a suggestion.
Yeah.
That legal counsel.
But it's not you.
Yes, sir.
All right. Any other questions of the members of the committee of the presenters? If not, I appreciate your input, Chairman Knight. Is there anyone else who would like to address the committee on House Bill 291? If not, we will close off further input. And Ms. Oliver?
I'd like to make a motion in the proper time.
All right. If there's no discussion among members of the committee, the chair will entertain motions.
Move to pass.
It's been moved and seconded to pass. Is there any discussion of the motion or amendments to the motion? Mr. Fleming.
Thank you, Mr. Chairman. As far as discussion on the do pass recommendation, I am going to vote for the bill today, Chairman Knight, and I'm doing it because of what you told me, that you will not be, your organization is going to raise their dues sufficiently to cover the costs that the Secretary of State is worried about in his letter, and that you won't be coming to the appropriations process for more money. That's why I want to vote yes.
That's critical. Yep. I think all of us see that. Thank you, sir. Any further discussion about the motion? If not, the chair will call for a vote on the motion. All in favor of a do pass House Bill 291 by LC 2959-15S signify by saying aye. Aye. Opposed, like sign. The motion carries.
Thank
and
you,
we
Mr.
do have a
Chairman,
do pass
and
on
members of the
291. Thank you.
All right.
Mr. Carson. We have next House Bill. Let's get the door closed as soon as we can. Hey, how you doing? Haven't seen you in a while. No, I enjoy seeing you. Oh, that. Thank you. We're here for House Bill 796. Representative Carson working off of LC 2959-76, I guess, since I haven't pulled the bill, but I hope we got the same one in the folder.
I hope that's correct, sir. I'm working off of LC 2959-76S. Is that what you said?
Yes, sir.
Great.
Why don't you present your bill?
Thank you, Mr. Chairman. If I may just open up by saying to the members of the committee, I appreciate Chairman Willard, your time and expertise. I think you and I have been working on this probably better part of 4 or 5 months or so forth, back and forth. But I appreciate your consultation and your advice on this. Let me talk about what this bill is trying to do, and it also includes feedback in regard to Chairman Powell's comments. This came about as a result of a contact I have in my community. He did some work. He's an interior contractor. He did some work for a public works project that basically built out the interior walls of a K-12 educational building here in the metro Atlanta area. About 2 years later, and the building and the construction and so forth, he won the bid, performed the work and so forth. He builds interior walls. Okay, so he is a subcontractor to a GC. This work was performed probably about 3 years ago. About 1 year ago, one of the groups that lost the bid to do the work filed an open records request to see all of his payroll and personnel records in regard to this public works project. And he fought that. He fought the legal action against him. He didn't think it was right to do that. Obviously, the invoices that are given by my contact, the contractor to the K-12 education, the Board of Education, obviously that should be open to open requests and so forth. But what we're talking about or not just even W-2s and 1099s. We're talking about personnel files. We're talking about names, addresses, Social Security numbers, hourly wages, hourly rates that he's paying his employees, how much overtime. All these kind of different details were wanted to be disclosed as they related to that project. Not necessarily their salary, although they could probably figure that out. But they wanted, it was more or less of a fishing expedition, because this group wanted to say, okay, well, what is this competitor that beat me on this bid to this K-12 construction project, what is their competitive advantage? How much are they paying the employees? Who are the employees? What kind of skills do their employees have, and so forth? So I took this to you, Mr. Chairman, and we came up with this language. We are, per the committee substitute that I just read off, we are not changing, per se, the Open Records Act under Title 50. And what this is doing is protecting two things: identity theft from a frivolous open records request to just go after some contractor just because he beat you out on a bid or she beat you on a bid. And secondly, we're, well, two things. One, prevent any kind of identity theft, and two, protect competitive advantage of a contractor performing services for a governmental entity. And as written, this would apply to city, county, or boards of education or political subdivisions within the state.
Okay. Thank you. Questions of the presenter? Yes, sir. Mr. Caldwell?
Yes, Mr. Chairman. The bill, even the bill we passed today in the House, as well as other provisions, already protect Social Security numbers and numbers of that type of effect. So why would they can't be produced now? And the bill that we passed today in the House says they shall be redacted in any form that is filed with the court. So why would we need this?
I don't know that that bill necessarily protects the names and addresses of the contracted employees of a private company and so forth. Obviously, you can't necessarily always release Social Security numbers unless there's a very good reason and so forth. I think this goes a step further to protect competitive advantage that contractors may have when they're giving their best and final bid to a government contractor.
Well, I guess I got one other question, if I might follow.
Sure,
Mr.
follow.
Chairman. Everybody knows where I live. Been living there forever. Telephone number's always been in the phone book. What's wrong with knowing who the employees are?
Again, it goes back to a competitive advantage of a contractor to provide those services, who their bricklayer is, who their stucco person, so forth, who their electrician that they typically engage, their plumber, and so forth.
All right. On this side, I think the first one we have was Mr. Weldon.
Thank you, Mr. Chairman. Representative Carson, could you help me understand what you mean when you say competitive advantage in the context of this bill that you discussed?
Competitive advantage in regard to, let's say you have contractor A and contractor B. Contractor A would have a competitive advantage, whereas not only did they may or may not have won the bid, but they may know more particular workers with that are skilled labor, and they may be they know more and better contact names for plumbers, electricians, machinists, welders, interior wall construction folks, bricklayers, and things like that. So this would prevent that contractor A, with a competitive advantage from having that data to who are their contacts, who's working for them, how much they're paying, and so forth, from competitor or contractor B who wants to know that information.
How does it, if I may, Mr. Chairman,
Yes, sir.
I've got a serious question on it.
All right.
How does that give them a competitive advantage just by knowing the contractors they use? I have some experience in that area, and usually it's not uncommon for the general contractors to know a myriad of subcontractors in each trade. I don't see how that provides a competitive advantage to any of them.
Could you rephrase the question? I'm sorry.
I don't see how this information regarding that your bill protects the payroll and personnel records of private contractors, subcontractors, performing services that's any governmental entity.
Mm-hmm.
I don't see how that's a competitive advantage, other than I'll pay you more, but that goes on anyway.
Well, that goes on anyway. Competition.
I don't see. Can you give me a direct example of how that provides a competitive advantage to a competitor B who lost the bid and they got solid grade?
I think I'd like to hear from some people in industry in regard to a specific example, if that's okay.
Well, I want to pose
But
specific examples
okay.
for you. Okay, here's what hypothetical.
Okay.
You have masonry contractors all over the state, and they bring in folks that are illegal aliens. They bring them in by the busload, put them in substandard housing, charge them rent, and pay them cash all the time. These are on governmental projects. Those guys don't pay they don't pay payroll taxes, they don't pay workers' comp insurance, they don't pay much of anything other than substandard wages.
Right.
And then out of those substandard wages, they're getting back rent that they're charging those folks.
Right.
Right? Now, that's a competitive advantage over a competitor A or B or C or D who is e-verifying his workers, paying taxes on their payroll, paying workers' comp, and they're the ones that are bearing the weight of that other contractor who doesn't have this payroll information that's available. And if that stuff's available, even though they redact the Social Security and private information, that is something that needs to be out there, it needs to be exposed, so that we can actually have competitive bids
Right.
among law-abiding contractors, as opposed to those who don't pay taxes and are not law-abiding.
Right. I would respond by saying this does not impact the E-Verify process in regard to legal workers and so forth.
I'm not asking you about
okay.
verify. I'm asking about your bill. What I'm trying to say is,
yep.
if this information isn't available, the people that are going to be getting this information are the competitors when they get beat out by 40% on a bid on a job, and everybody else is bidding, within 5% of each other.
Right. I would say also this, obviously this information in regard to the payroll, who are you hiring, how much are you paying them, and so forth, I would only presume that would be freely available to the governmental entity, the political subdivision within the state, the city, the county, so forth. That would be available to that government entity that would be engaging them. What I'm talking about is a third party, not necessarily with a directly related interest.
You're talking about competitor.
Competitor, yes.
And those competitors are the ones that are going to sign the bill. The governmental entity's not going to sign the bill because they're going to go with the...
Let me remind you to keep it to questions as opposed to arguing with the witness. Just make your questions. Always. I want you to just try to keep in line with the form of question, please.
Yes, sir, Mr. Chair.
All right. Anything further? I got it?
I would also like to say, in the bill, line 5, unless a court of competent jurisdiction upon good cause shown grants access to such records upon such considerations. So I believe that would, I'm not an attorney, but I believe it would seem to alleviate some concern there that a court of that jurisdiction would be able to award those records. What this is trying to prevent, Chairman Weldon, is frivolous searches, wide-ranging searches, just to have data, particularly in regard to names and addresses and how much you're paying your employees.
All right. Ms. Oliver.
It's line 1516 about court of competent jurisdiction.
Oh.
That implies to me that somebody has to file a lawsuit with a $235 filing fee to get in front of a Superior Court judge for a hearing that'll be scheduled between 30 and 180 days down the road. Is that your intent? Is that your?
It would be under a court order. I don't know what the exact processing fee is. I think the chairman might be able to.
$257.50.
All right.
That's the final
Could be,
thing.
maybe not. Who knows?
And there's no other open records qualification that requires you to go to court, is there, Mr. Carson?
There's no other open records
Open records request documents that requires you to go to court, is there?
I'm not aware of any.
We unfortunately deal in a world of rumors down here.
Right.
And the sensitivity around the Braves Stadium moving to Cobb County, and all of the questions are going to be raised about minority contracting and private partnerships. It's all going to make this bill get a little bit more attention than usual.
Oh, it's gotten some attention, I assure you. This, I will say, and I will risk my reputation and my tenure as a representative, this has nothing to do with the Cobb County Development Authority, the Cobb County Brave Stadium, or anything like that. The chairman and I have been working on this, I think, since probably about September of last year, 2 months before it was even announced. This has to do with a particular subcontractor, a contact of mine who has a business based in Smyrna. He does work all over the metro area, all over Georgia, really, but primarily in the metro Atlanta area. And I don't think he's even in the business of building stadiums. I understand that, Representative Oliver. I understand that's been in the paper and so forth. To me, that's been more making news than reporting news. And I have not had time to discuss this bill with the news outlets yet. I've actually been trading voicemails with an editor today.
Thank you. Ms. Evans?
Thank you, Mr. Chairman. To my friend from Cobb County, thank you for clarifying that this is not about our great project that we have going on in
Absolutely.
Cobb County, in Smyrna, actually. My understanding of the law, and I've been and I've actually looked at it, is that the Social Security numbers, bank account numbers, information like that is already excluded. And so if somebody provided that in response to an Open Records Act request, they would have messed up. But and I understand that you might want to protect additional information like addresses of employees or phone numbers. I don't have any objection to that. My question for you, though, is why would we want to shield from sunshine the amounts that our governments are paying for certain projects, and including the detail of what we're paying for individual workers, so that the citizens will have the right to look at that and determine if their elected officials are making good use of their taxpayer
Well,
dollars.
I believe this would not shield a group from filing an open records request to go ask for a city or a municipality in regard to the invoices that they paid to a contractor. Okay, so let's say you build a city hall, okay, and you say, I've already preserved the land, it's public property, I'm going to pay a contractor $1 million to build a city hall. Okay, I'm going to pay $200,000 for materials. I'm going to pay $200,000 for laying a foundation and concrete. I'm going to pay $100,000 for plumbing, $200,000 to go vertical with the walls and so forth. Whatever it is, those type of records and invoices, things that are being paid, that would be available still. Those invoices that are being paid by, say, the city of Smyrna, or Cobb County, or Fulton County, or what have you, those invoices that are actually paid by the government entity, the governmental entity, would still be available. What we're talking about is various groups want to, I believe, misuse the law and go a step further, whereas they want to go after the actual payroll records of a private business.
All right. Thank you. Over here, Mr. Rutledge. Waived. Mr. Mabra.
Thank you, Mr. Chairman. Representative, just have a quick question. These are private companies, but they're bidding on government jobs. Don't they have some type of expectation that the microscope is going to be on them for making a bid, and that their company will be subjected to open records requests where they will have to reveal this type of information? Granted, there are protections, as
Right.
Representative Evans mentioned, but
Right.
it's a government job. It's not you and I doing business. It's not a private setting. So there has to be some type of realistic expectations.
I think those realistic expectations are set forth, and thank you, Representative Aller, for clarifying. I must have it copied wrong. But when you have those realistic expectations, that would be covered on line 15, whereas it says, unless a court of competent jurisdiction shows that there are such appropriate considerations to release that information.
Mr. Chairman, if I may?
Yes, sir.
But also having the open records request where you can get certain information, the people who lost out on the bid, they provide a check and balance to be able to go through the documents and say, hey, look, this wasn't done right, and you're sort of cutting off the checks and balances of the system. I think it's supposed those people who lost, they should be entitled to look through that information for someone who's working on behalf of the government.
That's the question, or?
Yes.
All right.
I mean, isn't that true? I took one out of Will.
I feel like I'm in the well, Mr. Chairman.
Worse. It's worse. Go ahead.
I'll waive.
All right, you waive. Okay. No further questions of the committee. I will suggest, looking at the bill, I think it's a little broader than what you intended. I look at line 13. Yeah, we're reading the whole thing, 12 and 13. The payroll or personal records of a private contractor or subcontractor performing, it says services or a construction. I think you want to say services under a construction contract for a project, as opposed to as broad as you have it. I don't think you're looking to have a thing as broad as you're talking about.
Mm-hmm.
You're looking where somebody is a independent contractor,
Mm-hmm.
not receiving grants, not receiving something as a way of circumventing the work done by the local governing body, but saying we're looking for construction work,
right.
And that's where those records stop with really producing what has been the contract and the standards performed under the contract. Correct.
Right. That's
okay.
Correct. So,
thank you.
Would you be recommending that it say?
Well, appropriate time we'll take amendments.
Oh, okay.
Is there anyone else who has signed up? I don't have a signed sheet here, do I? Do we have a signed sheet? Who else is here that would? I don't know why we didn't have a signed sheet. I got one on here. Y'all have it signed. Does anybody want to sign up for talking on a bill? Do so immediately so I know who to call on. Yes, sir. You can stand up, Mr. Carson, and we'll be having other people testify.
Okay.
Have a seat and tell us who you are and who you represent.
Thank you, Mr. Chairman. Jim Collins on behalf of the Georgia Trial Lawyers Association. I've got a handout here. Basically, I tried to give it to several folks. If anybody wants it, it's just basically the code that we already have. This is legislate. Do you need a copy? Yes, sir. If I can get somebody to hand those around, that would be excellent. Basically, this is already taken care of in code. This is a problem that is it's a solution in need of a problem. There's one case that's been filed. That case has not worked its way through the court system as I understand it. We have in general intent, legislative intent, the desires to have open access to records when you're dealing with the public. That's absolutely clear from the code. There are times where public disclosure is not required. One is when there's a pending bid. In other words, if there are two competing entities that are bidding, their bid is not open until after that bid is awarded. That's already there as an exception. Additionally, if you look at 20A, it reads records that reveal an individual's social security number, mother's birth name, credit card information, debit card information, bank account information, account number, utility account number, day and month of birth, etc. That's also an exception that's not released under open records. And then in 34, you'll notice it says trade secrets obtained from a person or business entity that are required by law, regulation, bid, or request for proposal. My understanding of the definition of trade secrets is it includes financial data, just the kind of data Mr. Carson's talking about. So I think it's already taken care of, and what it does, it shifts the burden from the entity that wants to keep the information secret to the taxpayer. And there is an opportunity in the last sentence. In the event the entity wishes to prevent disclosure of the requested records, the entity may file an action in Superior Court to obtain an order that the requested records are trade secrets exempt from disclosure. So this takes care of the problem in law that we already have for a situation we haven't gotten there. There are other concerns that I've expressed in the subcommittee, but I haven't had a chance to share this with the committee yet, and definitely wanted to provide that today.
Thank you, sir. Any questions? Yes, sir. We do have a question. Mr. Fleming.
Thank you, Mr. Collins, for coming today. Is the Georgia Bar Association subject to open records request?
I'm here on behalf of the Georgia Trial Lawyers Association.
I realize that, but that's not what I asked you.
I don't know if the Georgia Bar is. I don't believe they are.
Okay. Do you think they should be?
That's an interesting question. I don't have a thought about that.
Well, let me ask you about this question. Let's say in the future, because you do a very good job down here, you were hired by some quasi-governmental entity, and then someone filed an open records request for your assistant's personnel file that helps you. Should they be able to get that?
If I'm doing business with the public, then I've made a bargain with the devil, so to speak, and I've made a decision. I want to take those public dollars. Yes, I should be held to a different level of scrutiny.
So if your secretary was late last year, for example, and you reprimanded her and put a letter in her file, how does it serve the public good for somebody to serve an open records request on you to get your secretary's reprimand from last year?
I think the real issue here is if, for example, I hired a secretary that happened to be the immediate family member of somebody very important down here, and I use that hire to get a specific contract of public dollars, I think that's very much in the public interest to know that I hired somebody and maybe I'm paying somebody a $250,000 as a secretary so that I could get a $24 million contract. It's clearly some type of a shenanigans going on, let's say that. Worth looking at a little bit more. Not that I've ever done that, for the record.
Okay. Speaking third party, okay. Nothing further of Mr. Collins. We appreciate your comments and input.
Thank you, Mr. Chairman.
Next, we have Mr. Mark Woodall. Come forward, Mr. Woodall, and tell us who you represent.
Thank you, Mr. Chairman, members of the committee. I'm Mark Woodall. I represent Associated General Contractors for the commercial builders located throughout Georgia. Mr. Collins clarified a number of issues that were raised earlier. I want to, for the record, Mr. Chairman, my organization very much supports our open meetings and open records law. We think in the public procurement process, sunlight is a great purifier. However, having said that, and again, Mr. Collins clarified, one of the exceptions are pending bids and proposals, so my competitors can't access my bid while it's fluid and use it against me in the competition. When this issue was brought to us in this particular bill, we said we absolutely would support protecting our Social Security numbers and our individual salary and benefit packages. When my bid is awarded, if I'm awarded a contract, and one of my competitors wants to see how I got the bid, go through either the bid or proposal, they see the number. They may see the masonry contract, what it was for, or the electrical, and all the components that make up my bid, but they do not see that John Smith is making $10 an hour with this benefit. I don't even know what the other employees in my office make. Probably there are some folks around this table with law firms that may provide services to a local government or another state agency. Would that information be subject to an open records request, finding out what other people make and benefits package? So we absolutely support open records, open meeting, accessing the bid, holding people accountable, but it doesn't dive down into the actual employee's individual salary. I'll be happy to try and answer any questions.
Ms. Evans?
Thank you, Mr. Chairman. Thank you for coming today and testifying. You mentioned some concerns about pending bids, and I just want to make sure, do you agree with me that under the law already, 15-18-72, pending bids are already exempt from
Yes,
open
ma'am.
records? So that's not really the concern.
Not at all. And we support folks having the ability after award has been made or something's been rejected for folks to come in and be able to review and find out that there's a masonry subcontractor that's 40% cheaper than everyone else. And that should tell you something that's, if everyone else was in a range of 5%, something's going on there.
Okay,
But it
thank
doesn't tell you what each individual is making.
Thank you. Over here we have Mr. Kelly.
Thank you for coming before us today. I think we know that, like Representative Evans says, that pending bids are already covered here. But for instance, if there's a large school system and they're going to build 5 identical schools, but they're going to bid each school contract out separately.
Okay.
So the first contract, contractor A gets the bid, and they bid against contractor A, B, and C.
Mm-hmm.
And so, knowing there's 4 other schools to be built, contractors B and C then request the records from contractor A from his successful proposal.
Mm-hmm.
And then they take the list of employees and subcontractors that they use. They immediately start contacting them, offering them 2% more or 3% more than they made from contractor A to begin with. Is that something that could take place right now? for the next 4 schools?
It was not my understanding, and I'm not an attorney, Mr. Chairman and members of the committee, it's not my understanding that under our current open records law, that individual payroll information could be accessed under an open records request. The bid and proposal absolutely can, but individual information on the employee, it's never been my understanding that that was available.
Okay.
All right. Thank you. We have questions over here of Mr. Weldon.
Thank you, Mr. Chairman. And at the risk of
Beating a horse.
Sir?
Beating a horse.
Well, bringing some concern about practice in Cobb County, but not Smyrna. In Marietta, isn't it true that in Marietta the new courthouse was built by workers that were illegal aliens and residing in Georgia illegally, and that there was a big news report, I think 2 years ago when they were constructing, may have been 3 or 4. You know, it's my age catches up with me. I kind of lose track.
You got
of
a
that.
question? Want to ask?
So I mean, that's what happens, isn't it true?
My understanding of the story was the prime contractor was properly verified. The masonry sub who they contracted with was properly verified, and they secured documentation. My understanding is that party then contracted with 1099 independent contractors that were not properly verified, and that's my understanding of the story.
And is it true that causes a disparity between competition between or among those who compete and e-verify, take out taxes, pay taxes on their employees?
Weldon, we want all the folks to follow the rules, because those that aren't enjoy a competitive advantage over those that are. Absolutely.
And would it be your opinion that what's being asked to be codified here in House Bill 796 would provide cover for that information? It's already covered in, or already handled in House Bill 796. In the actually not House Bill 796, the law we already have on the books.
I'm not sure I understand the question.
All right.
We think the information from the company absolutely needs to be accessible. We don't think individual payroll information is appropriate under an open records request.
Mr. Mabra.
Thank you, Mr. Chairman. Quick question. Open records requests, they go to government.
Yes.
When you bid on a job, help clarify, I guess getting mixed up here. When I bid on a job, say I'm a construction company, am I sending in a personnel file on my employees for the bid?
No.
So they wouldn't have that information in the first place, would they?
Agreed.
Okay. Thank you. No further questions of Mr. Wall. We have 2 other signed up. There's Holly Manheimer, I believe it is, and Mr. Tom Clyde. Please come in and have a seat and identify who you're representing, please.
I am Holly Manheimer with the Georgia First Amendment Foundation, the Open Records Group. With me today is Tom Clyde, one of my board members and a media lawyer. I'm going to let Tom do the heavy lifting today in terms of talking. I would say, though, that many of the comments and questions asked by all of you go to the meat of the issue. We think that the Open Records Act, as it exists today, covers what is sought to be exempted by the current 796. All the folks here have asked the questions about personnel, payroll data, things like that. We think what we've got in the law right now, particularly based on what we did in 2012, adjusting some of these exceptions to the open records law, covers what we have. So we would be against the bill, but I'll let Tom speak more fully.
Sure.
Please
Thank
do.
you. Thank you very much. And as Holly explained, I'm a lawyer that represents the media and frequently deals with the Open Records Act and the Open Meetings Act. So let me jump right to some of the key issues that have come up already today. First of all, Representative Willard's proposed change to the law is enormously important. As it's currently written, it would undo literally decades of the Open Records Act. So changing it to under is very important. But even with
and
that
a contract and a construction
in a
contract.
construction, exactly. Yeah, so it would narrow it down to the role to the construction environment. But even in that role, this bill would interfere in legitimate inquiries into the performance of construction subcontractors in public projects. And let me explain a little. Let me touch on a little bit of the issues that have come up today. In terms of identity theft, the current Open Records Act completely protects individuals. The Attorney General's legislation that was passed 2 years ago carefully went through and eliminated from records that have to be produced under the Open Records Act all of the identifiers that are used in the identity theft concept. So that is not a risk under the Open Records Act. People have also brought up the idea that unrelated employees that weren't involved in a public works project could somehow have their records have to be disclosed under the Open Records Act. That's also incorrect. The only records, the only individuals whose records have to be disclosed in an Open Records Act request are those that are performing a service for government, those that have voluntarily assumed the duty and the responsibility, have in a sense accepted the honor of performing work for a state or local government and are taking taxpayer dollars. It is their
service contracts you're talking about.
Exactly. Contracts either performing a government function or performing a service for the government. But it is those employees whose payroll records and personnel records are potentially accessible in limited ways under the Open Records Act. And our courts have recognized many times that makes good sense. We've raised by letter to the committee before that the Court of Appeals has previously ruled, for example, that being able to see the records of private employees that drive school buses is critically important to know whether they are safe and competent employees. The same is true on construction projects. If your municipality is undertaking a major construction project, it is a legitimate inquiry by the media. If there's allegations that it has not been competently done, for the media to say, we want to see the personnel files. We want to see who are these people that are building this critical piece of our infrastructure. So there is legitimate inquiries that will be cut off by this bill, and the idea that you can go to a court of competent jurisdiction for access is really not a solution. That is an enormously difficult undertaking for any entity, for any individual, even for a media organization. It is only undertaken in the rarest circumstances. As a practical matter, that ends up putting virtually all of these records off limits. It doesn't solve the problem. So ultimately, this bill, even in its more narrower form, will interfere in access to legitimate inquiries into the performance of services for the government in construction projects.
Thank you, Mr. Clyde.
Thank you.
I have a question of Mr. Fleming.
Thank you, Mr. Clyde, for coming today. And you work in this area of open records, is that correct?
I do.
And who do you work for, I'm sorry?
So I work for Kilpatrick Townsend.
But your client in this matter?
So I represent the Atlanta Journal-Constitution, WSB-TV, and other media organizations.
Okay. And Ms. Manheimer, you work for?
The Georgia First Amendment Foundation and myself.
By yourself. But so now most of the newspapers that I'm familiar with in the state accept public monies by taking legal ads, do they not?
They occasionally do. Some do and some do not.
That's correct, but the overwhelming majority of newspapers in the rural areas particularly take public money through legal ads. Is that correct?
That may be the case. I don't know the answer to whether that is the overwhelming majority or not. There's a lot of newspapers, but I take your point.
Yeah, right. So I can file an open records request to any newspaper in the state because they take public funds and find out how much the publisher makes, how much he pays the secretary, and also the stuff that's in the secretary's personnel file, correct?
No, that's not correct, and nor would it be correct that I could file an Open Records Act with Holder Construction and see every single one of their records. All that the Open Records Act does today, and all it has ever done, is allow you to see the records related to the performance of a public project. So in connection with a public project, you're going to be able to see how that private contractor performed because it was doing a government service. So yes, in connection with certain advertising that's provided for a government agency, the Open Records Act could potentially apply in a narrow area to a news organization. But it wouldn't apply to, for example, the records of the publisher in that sense.
Well, hold on a second now. They're providing a public service when they run that legal ad, correct?
They are.
And anybody who provides a public service is subject to the open records request if they accept public funds, right?
No.
No?
In other words,
hold on, we're making good law here. This is recorded. I want you to continue.
They're subject to the degree that they're providing services for a government entity.
So running a legal ad is not providing a service for a government entity. Is that your testimony?
It could be providing a service for a
Okay.
government entity, but that wouldn't give you unfettered access to the records of the larger organization. That's never been the reach of the Open Records Act, and that's not what we're suggesting. I don't think anybody's ever interpreted the Open Records Act in that way.
So, but it would provide me access. You're testifying to the Secretary's record of the engineer who's providing a service to the local government. Is that correct?
I think that it would really depend on the role the Secretary played with that public contract.
So, in other words, only if somebody in the office touched the project, so to speak, would they be subject to open records requests then?
In some sense, in every situation where a private organization is providing public services, there's a line that has to be drawn. Where is the area of what's the reach of that public service within the organization? I'll give you examples. IBM provides, serves as a vendor to a lot of municipalities, and provides and fully understands it's responsibility. If there's an issue with respect to that vending relationship, they provide their records. But that doesn't mean that we get access to the highest levels of IBM's information. That means that vending relationship with the state of Georgia or with a municipality is subject to the Open Records
And
Act.
who draws that line?
Lawyers and the courts.
And the legislature?
And the legislature,
But
absolutely.
you just don't want to draw it in this location.
What I am suggesting is that this is a traditional part of our Open Records Act, and in many circumstances is a very legitimate inquiry in order to find out that public works projects are being competently performed.
Thank you.
Thank you. Ms. Rutledge, you have a question? You wave? All right. Mr. Kelly, you have a question?
Maybe a concern here for a minute. Maybe you could just clear it up for me. So my brother works for a landscaping company, and the large part of what they do is they cut school properties, which are obviously done through competitive bid processes. Right now, could someone subject the company that he works for on a specific proposal and get his name and home address?
So home addresses are traditionally protected already under the Open Records Act. Could they get his name if he's performing work on a government facility? If he's performing work under a government contract, they could probably get his name.
But all he's really doing is cutting the grass. He just rides the lawnmower for him.
Exactly. He's riding the lawnmower and he's cutting the grass of a government entity, and in a sense being paid by taxpayer dollars. The government made a choice either to hire an employee to perform that function or to hire a private vendor. It chose a private vendor, but in doing so the taxpayer didn't lose their rights to see how that work is performed.
Thank you. There are no further questions, so appreciate your testimony today before the committee.
Thank you.
And we have no one else signed up to speak, so we'll close all further public comment. And you have comment?
Chairman, I just
come forward, please, and state your name and who you represent.
Chairman, my name is Ashley Jenkins, and we represent the Associated Builders and Contractors Group, which are mainly subs, and they are certainly in support of this bill because they want to prevent the fishing expeditions of their payroll and their personnel for reasons that have been stated 100 times, but they're very much in support of this bill.
Thank you, ma'am. No questions. We'll close off further public comment. The bill is now in the breast of the committee. Is there any discussion among committee members? And you have a motion appropriate time. All right, no further discussion. The chair will entertain motions.
I move to table, Mr. Chairman. Second.
The moving the table takes precedent over the other motion. It will be voted on without discussion. All in favor of the motion to table signify by saying aye.
Aye.
Opposed, like sign.
No.
I think the chair rules. Without a show of hands, I believe the motion. That's right. I think the motion to table passes, and the bill is tabled. Thank you, everyone. We have next, I believe, I see Mr. Martin. I'm going to call up HB 819. Something may hopefully take a short time to do, and I want to be sure we're working off a bill that we have the right number. We had a problem on one earlier, but I'm showing here 4109S, Mr. Martin.
No, sir. If I may,
one of the file
344187S is.
All right, under House Bill 819, if you look in your file, we have LC 344187S. And Mr. Martin, you may present the bill.
Mr. Chairman, I have not been down to your committee this year. I enjoyed it, and in so doing, I brought a law book so that I could appear to be as
pull it out of my case over here. I want you to be sure to put it back.
No, sir. This is from 2010, so I'm at least 4 years behind. I do appreciate the chairman's indulgence with a regular fella here trying to do this. I believe you have heard this bill and had testimony on it previously last week, and I will bring you the substitute today. We have removed some language in the bill relative to some lien language, and if the chair would allow me, I will actually say we removed the due diligence language on page 1 of the old bill, and I'll talk to how we substituted it. We removed sections 3 and 4 of the old bill, which dealt with someone without a lien being able to purchase a tax execution or a FIFA, and therefore we did not then need to repeal the section of how that treatment was to be done if that in fact occurred. So both of those sections 3 and 4 of your LC 344109S were deleted. We got some later information and made changes in what was section 5, and I'll go over the bill now if it please the chair. The crux of the due diligence, Mr. Chairman, we worried and talked to people between the committee meetings of adding additional due diligence to everyone before they filed a FIFA. And so what we decided in talking with some of the folks that are in the business doing that for the counties, that we would move our due diligence request, our new due diligence requirement, if you will, only to a place where if the county was going to choose to market those to a third party. Right. So if they were going to be sold to someone other than the owner of the property, the due diligence needed to be done. That way we would not bother the vast majority of folks that aren't going through that. So that's what you'll see. That's moved now into 48.3.3. I also bring to the chair's attention on line 16, the word after is now before. I believe that was the way the law was really always interpreted. If the learned members of the committee will read it, I think they will see that's an obvious change, and if you will, was almost a Scribner's error in the original bill. That was pointed out by the chairman to me as well as some others. The rest of section 1 of the bill is making the language of current law match the new definitions and fixing some verbiage. Section 2 of the bill is where we place the due diligence. I guess I perhaps got a little ahead of myself, 48.3.19. So we defined, updated the definition of due diligence, and then we also put in code at line 76 through 86 of how that due diligence execution would happen.
Only as executions are going to be transferred to a
yes,
third
sir.
party.
It is prior to the transfer is where it says now. Prior to the transfer under the code section, the officer will have these duties. And it further says that after the due diligence is done, they have to give time for the people to pay, and if they pay at full value at execution, including principal amount, the principal amount, penalty, and interest, then it wouldn't. The sale of the FIFA would not go through. So basically, what we're trying to do here is do everything we can to contact the people that owe the taxes, get the taxes collected, and we think that would be good for the property owner. If the chair would allow, in your Section 2 in LC 344187S, if the chair would allow me to make a suggestion, and if the committee chooses to move forward on the bill, I would request that the committee remove lines 87 through 102. We're continuing to work on that language relative to the timing of the sale of that and how the penalty may be appropriated, and we need some more time to continue to work on that.
We're getting ready to pass the bill out. You got a language you want to change?
No, sir. We do not at this time have that. That's what I talked to the chairman earlier on today, that if we could remove that, I believe we will have an opportunity to work with our colleagues across the hall. Yes, sir.
What does that part do under B? What is the intent of it?
The intent under B is to more properly align the allocation of the penalty that accrues to the holder of the taxes due on a given date. And what we want to do is more fairly apportion that so that there's not just a single date, or at least in my mind, Mr. Chairman, so that there's not just a single date that the FIFA, if you will, if $1,000 of taxes is due this day, when another day goes by, there all of a sudden is 10% penalty and there's $1,100 of taxes due. We want to try to work a situation where we encourage the taxes to be paid earlier and the fee, quite frankly, to be avoided so that the taxpayer can pay that.
Are you talking about them doing a step proposal as far as incurring penalty?
Well, actually, sir, if and that's why I apologize to the chair. This has just come up today and talking with someone across the hall. But my thinking, honestly, sir, is to try to come up with something to allow the tax commissioner the opportunity to realize the anticipated value of that penalty before it actually accrues. If you would look at it, say, in a bond that would accrue interest on the 31st of a given day, we all know on the 29th, most of that interest has been earned, even though it would not be paid on that bond until the 31st. But if I were going to liquidate that bond or sell that bond in a free market, I would get more than the principal amount of the base amount of the bond. I would take into consideration that I'm 29 days into 31 of earning that. So we'd like to work into a situation where the tax commissioner could get additional monies that would accrue to the county for the sale of that.
I'm not sure how you're going to do that.
I think, and thus, sir, I need a few minutes. I think you would do it back in 48-244, where that penalty is actually defined. I think there's an opportunity to bifurcate the penalty in there, but I'm going to need some legal assistance in order to make that happen. In the interest time, I make that suggestion to the members of the committee and the chair to allow us to work with that. Moving forward in Section 3, you may have some people that wish to testify, but we did change the way I think what is commonly referred to as a super lien works, and it's charged penalties that or the return that's charged would be on the total amount of taxes, interest, and penalties and other fees, rather than the amount, the 20% that would be required to redeem the property. So if you will, it's not quite hitting the taxpayer in the head with a sledgehammer quite so badly. The language on 125 through 131, Mr. Chairman, is exactly the same. It has a different section number because the sections have been deleted and added, but that's exactly the same as you had seen in the previous version of the bill. And then Section 5 is the exact same language with different sections.
Tell us what Section 5 does, so everybody's aware.
Section 5 repeals 48-5-163, whereby the tax commissioners receive an amount. I believe the amount is 50 cents for each property or each lien that's FIFA'd or sold.
And we only know of one tax commissioner in the state that's used that provision in recent years, and what we call the tax officials, the elected tax officials of Georgia, are in favor of that being taken out. Is that
yes,
correct?
sir. I've not had anybody actually, even the gentleman in question has not contacted me about taking that out. But
okay.
No, sir, I haven't had any reservations on that. And that does accrue to an individual, not to the tax.
That's correct.
The overall good of the order of the county.
Not the office, but the individual.
Yes, sir.
All right. Thank you. Goes back to our old fee systems that we still have some old laws on our books about, correct?
Yeah, yes, sir. You would know more than I, but yes, sir.
Any questions of Mr. Martin? If not, I appreciate your explaining the bill to us. We have several people who would like to address the committee. I have Mr. Dan Ray.
Mr. Chairman, do you mind if I sit here so I
Please.
can make notes?
Sure. Mr. Ray.
Mr. Chairman, I don't need to add anything. Mr. Martin today.
You're happy with it? All right. Well, thank you. Mr. Kevin Waters.
Mr. Chairman, I had testified previously regarding this bill. I'm happy to answer any questions. If there are any further questions, you want me to elaborate upon anything?
You represent also the tax officials, is that right?
I do not.
Oh.
I just represent Kevin Waters.
That's right. Individual dealing with the super tax lien issue. I'm sorry.
An individual who's dealt with this and a concerned taxpayer and citizen of Georgia.
All right. Thank you. Then we have Mr. John Walraven and Mr. Richard Robinson. Y'all want to come together or separately?
Together, is that all right?
Come up here and have a seat over here. All right. Give them to our, we got a staff that does that. Give them to the lady over there and we'll get them passed out. Time's important right now. Tell us, please, your name and who you represent.
I'm John Walraven with Ray Investment Group, a subsidiary of Investa Services. This is my client, Mr. Richard Robinson, of the same, and we're back. Thank you very much for the opportunity to appear before your committee. I would like to applaud Chairman Martin for having his door open, being and working really hard. He's done a blue-collar job on this thing, and I really appreciate his hard work on this bill, Mr. Chairman. And I do want to really applaud the concept that he brought to you to strike from the lines from 87 on through the...
His suggestion.
I'm sorry, his suggestion. The reason being is that when I was in committee prior to today, we talked about what this would do, and it would cause the tax commissioner to hold on to a lien for the better part of a calendar year at a minimum, whereby the 10% penalty that would accompany that tax lien would fully vest with, in this case, Fulton County. Fulton County collects taxes for, I think it's 15 different governments, including cities of Sandy Springs and Alpharetta and Johns Creek and Roswell.
School districts.
And school districts, APS and Fulton County, and also the city of Atlanta. But they make up only 22% of the entire tax base. So even though 80% of the taxes collected by the tax commissioner is on behalf of these other governments, 100% of the penalty under this language would vest with the tax commissioner for essentially not collecting the taxes. My client is the largest lien buyer, and what they specialize in is providing liquidity to government. The only beneficiary of this language in the end would be Fulton County's general fund. They would keep the entire 10%, where the cities and the schools would have to wait on their money, and there's no guarantee of when it's going to come. Excuse me?
You mentioned wait on there. How long are we talking about waiting?
Until the taxpayer that's delinquent decides to pay.
No, I'm asking, as I read the bill, the time frame was as of either the first of the year, which means the tax bill has come due in Fulton County, as an example. Was it November?
This year?
November and December.
And so we're talking about waiting until after the first of the year or 90 days. So you're talking about a time frame from November the 15th, I believe, until at least after the first year when the penalty accrues, or as much as 90 days.
Exactly.
So it's not a whole year.
Well, in your example right there, it's not.
Well, that's in fact what happens, isn't it?
Well,
It's not a or, it's an and.
all right. Well, does that answer your question, Mr. Chairman?
it's not you kept using the term a long time, a year, up to a year. It's really at the most 90 days.
But if the lien was sold, if a December tax due bill became delinquent, it would be delinquent in the next calendar year.
Correct. By definition.
It's 90 days.
Correct.
By the term of the bill. Is that correct?
Yes, sir. So
All
we're
right.
talking about the next calendar
Before
year.
they could sell the tax lien to a third party. That's the only time we're talking
It would be
about
over a
it.
year, yes.
Okay.
90 days.
No.
We disagree. Would you please offer the
Sure.
chairman an
It-
explanation?
It's not an or, it's an and. So if a bill is due December the 15th, the earliest that a FIFA or a tax execution that could be issued would be January the 15th. That would be a new calendar year. And the way this bill is written, it would be the following year would be the earliest.
No. I disagree with your interpretation, but that's what lawyers would do. But it says not until the next calendar year, meaning after January 1, following the calendar year in which the execution was issued, and not until at least 90 days have lapsed from the date the tax were due.
Correct.
So what we're saying is the taxes became due November 15th. You have to wait till the next calendar year, which would be January 1st, for that. Because that's when the, correctly tell me if I'm wrong, that's when the penalty assessment applies, is as of January 1, correct?
No, sir.
Or 90 days, or what?
The penalty accrues 90 days after the due date of the various bills.
All right, so that's what the bill addresses. It's saying that 90-day time.
Right, it's and it says a calendar year.
But back to my original example.
All right.
If a lien is not issued until January the 15th, which is 30 days
Okay.
after the due date, it would be a whole other year before that would be
So
available
if we
for
change the
transfer.
and or, that would resolve that issue regarding having waited at least 90 days.
That would resolve your issue in that
All right.
paragraph. Yes, sir.
Very good.
Thank you, Mr. Chairman. Sorry that was so murky. So to address this new language from 76 to 86, this would, and since again we refer to the only tax commissioner who currently is taking advantage of this statute, it would obligate the tax commissioner's office to perform a due diligence search on every property owner who failed to pay their taxes on time.
If they're going to sell the tax.
Right. So
And the
Fulton
bill-
County, which
and
is
the bill came back.
no, sir, that does not what is there. It doesn't say anything about
Okay.
a bill coming back. That's the tough part about this language, is that it would require the government to go basically verify addresses of delinquent taxpayers, whether or not the mail was returned. So instead of spending time trying to collect the delinquent taxes, they'd be spending time trying to verify 53,000 addresses.
Only if they're going to transfer it.
But
Correct.
for how many years in a row has Fulton County transferred liens?
6 or 7 of the last 10.
Okay. So it's a pretty frequent transaction that occurs, and that's what all these cities and school boards are, how they're maintaining their liquidity.
Need to have you hurry up.
Well,
finish. We're going to run short of time. We're going to be, it's getting close to 6 o'clock.
Mr. Chairman, I still think, in my opinion, that all we're doing here is trying to prevent Fulton County from transferring liens in Section 2. In Section 1, it made them less marketable. In the first draft, in this bill, there's I don't know how long it'll take for 53,000 delinquent taxpayers to be contacted to confirm their address, but I can't imagine it'll be cheap, that it would be done with the current amount of staffing that the county has, or that they would even get to transferring the liens in the end, and the final result would just be enriching Fulton County's general fund by 10% of the total tax base that's not paid on time.
You call that enrichment. I call it something that's due for the failure of to the tax coffers of the county based upon the failure of someone to pay the taxes. You got a question from Mr. Lindsay?
I'm not sure if it's better directed toward Mr. Walraven or Mr. Martin or, for that matter, the chairman, but I'm still stuck on the idea that the these taxes which are delinquent are, what, 78% of them are owed to the school boards, the cities, and yet the county is going to get 100% of the penalty. That just simply doesn't make sense to me. And and I understand the chairman's desire to figure out to make sure that this is more fair to the taxpayer. That certainly makes sense to me. But I'm still.
I think you have to look at other part of the general law to make the change there, because it's just been practiced that we don't have the penalties going beyond what is the office and the coffers of the county where there is a delinquent bill.
Mr. Martin. And I understand it, but my concern is the timely paying of taxes so that the government can operate and not raise other people's taxes who are coming in on time. And that's just.
I want you to ask a question. You got questions you want to ask?
That's the question. How can we? Is there a
change the
possible
law
way to make that more equitable to the cities and schools?
I'd be happy to entertain a bill if you want to bring one and look at that.
I've only got about 14 more days, Mr. Chairman.
Well, bring it to me and I'll take care of it. Yes, sir. Mr. Martin, yes, sir.
May I answer the congressman's question? Serious, Mr. Chairman, you point out a good thing, and I'm not as familiar. All joking aside, I've carried this law book around for 2 days and tried to get familiar with this, and you've been a great help to me. But the section of general law you refer to, the tax commissioners also brought, there appears to be some ambiguity as to how much penalty accrues. If it's a $2,000 bill and 1,000's been paid, some people think the 10% is on the whole 2,000. Some things on the 1,000. There's questions about that, so I would agree with the chair. That's a portion of the law that we do need and perhaps should address to move to that, and we could do that in here if we have the opportunity.
I don't think time-wise you're going to have the chance to do it here, but we can certainly entertain a bill that does look at that overall issue. We have another question over here. Is that Mr. Weldon?
Yes. Thank you, Mr. Chairman. To the presenter, I think I see this bill will diminish the ability of those who purchase these the outstanding tax FIFAs from the county to get leverage on the amount of the return they can get with the 20% rule. Isn't that correct?
20%? What's the 20% rule?
The 20% that they get as a premium for paying the taxes that are delinquent.
I don't know. There's a 10% penalty, those you refer to. But what you have happen is immediately there will be accruing a 10% windfall to a buyer if it's done right at the time just prior to the selling of the tax execution to a third party. So in effect what you have is a third party buying the tax execution will be acquiring a 10% premium, plus then they earn 1% per month for every month the tax execution remains outstanding. Is that what you're talking about?
Yes, sir. That's I think that's what I'm referring to. Then once that when the tax FIFA is purchased, that gets paid, and all the taxes for this is only for delinquent taxpayers. That tax is paid, and then it's distributed to the schools and the county appropriately.
Correct.
My concern about the philosophy of the bill is this takes out the real teeth in this bill, and on lines I guess in section 3
I want you to ask questions. If you got questions before we go into a discussion of it. If you got
okay.
We're going to have a discussion on the bill, okay. But I want to just complete questions to the witnesses. Anybody have any further questions of Mr. Walraven or the other gentleman, Mr. Richardson, is it?
Mr. Robinson.
Robinson, excuse me.
No problem.
Lost my sheet.
Thank
No other questions? All right.
Thank you, Mr. Chairman.
Thank you both.
Thank you, Mr.
Anyone else wish to address the committee on HB 819? All right, we'll close off further public comment. The bill is now on the breast of the committee. Do we have discussion among the committee members? Hold on just a second. Any discussion from, did you have some questions or comment, Mr. Welling, you want to talk about?
Yes, Mr. Chairman, thank you.
All right.
On, in section 3 of the bill, I think on line 111, the purchaser is entitled to, I believe, a premium of 20% of the amount.
This, let me, if I respond to that for you.
Okay.
This addresses what is called the super lien issue that has been used by some persons as a way of substantially increasing that premium of 20% by bidding up the amount on a foreclosure basis as a way of then acquiring that, and usually not from the delinquent taxpayer, but from a usually a financial institution. We got some bankers here to talk about. They want to, but they didn't come forward. But you have what they call these super tax liens, and then in order for the banks, mortgage companies to protect that property, they got to pay out that money, and it goes to the one who bid up that amount.
Yep. So
there's a great windfall that comes not from just paying the 20% penalty on the tax amount, but on this amount that they bid in, using, because what they do, they go out and acquire another judgment that may be on record because of a failure, say, to pay your garbage collection fee or something else. They use that as a way of having the right to avoid going through the normal foreclosure process on a tax execution and bid it up. So we're trying to modify that as a way of getting that where they cannot do that. Well, you read the language. Any amounts paid in excess of the total amounts is reading from line 116. Any amounts paid in excess of the total amounts of the taxes, interest, penalties, and other fees satisfied by the levy, including the advancement of additional taxes on the property, shall bear interest at the legal rate. So you cover it by limiting it to what they're going to have as the amount. And I go back, I'm sorry, line 112. The total amount of taxes, interest, penalties, and other fees satisfied by the levy for each year. So we've left it that way as being the amount only that 20% can apply to. That's what
yes.
we did. I'm sorry to be to jump down the line there. But that's what Section 3 deals with, is what we call the super tax liens. Other comments over here, Mr. Lindsay?
Yeah, a question. You know, given the back and forth a moment ago, Mr. Chairman, just sort of walk me through, if you would, combining on Section 2 the A1 and B1.
Give me a line, I'm sorry.
I'm sorry, 76 down to the end of Section 2. Just go to, all right, the tax is due on November 15th.
Correct.
All right. Walk me through the process that underneath this law, tax commission is going to have to wait till January 1 to sell it, correct? That's the earliest he can sell it.
Earliest, yes, sir.
Does he have to do this due diligence?
Only if he intends
to sell it.
To sell it.
Well, that's what I'm saying. Let's just assume he intends to sell it.
Correct.
First off, he can't sell it till January 1. And does he do the due diligence before January 1 or after January 1? How's that work?
He certainly has a right. I mean, I don't run his tax office, but certainly
if
you know you got a delinquent tax bill, and your expectation is you're going to sell that, you can start doing whatever due diligence is necessary to prove that the tax bill didn't come back. So the likelihood, the expectation is the bill was delivered. It was delivered to the property. So is that you notify the person who's at that property if they're still the same individual who owes the taxes that's coming due.
Yes, sir.
So you're doing whatever you can just to verify that the bill is going to the right person hasn't been a sale or transfer of the property that may have caused the bill not to get to the individual who owes it. If the bill came back in the mail, you can have a review to find out, well, why did it come back? So there's several things that are asked for, and you look up here above it, when we talk about due diligence, we speak of the checking internet search engines and people finder database, which include the use of online address verification products and services.
Yes, sir.
I think we as lawyers use that ourselves from time to time. I do.
Yes, sir. Let me ask you this. All right. I think someone mentioned there were 53,000 parcels in Fulton County. Is that? So 53,000 delinquent. Let's just assume that the tax notice went out back and 1,000 or 5,000, I don't know. Let's just assume 5,000 came back, bounced back, couldn't be deliverable. Now, do they need to do the due diligence on those 5,000, or do they need to do the due diligence on all the tax liens?
Only on those that they're anticipating to sell. Third-party transfers.
Well, let me phrase it another way. Let's just say, I'm giving up a hypothetical figure, the 10,000 delinquent tax liens. They've sent out the notice.
Gone from 5 to 10 now.
What?
Gone from 5 to 10?
Well, not because I can do 10.
All right.
It's an easy number. 10,000. You sent out 10. You got 10,000 delinquent people. You sent out the notices, but only 1,000 or so the mail comes back because undeliverable. Can the tax commissioner assume that the 9,000 are correct addresses?
Well, if they pay the taxes.
I guess what I'm asking is, does he have to go and check on 10,000, or does he have to go and check on 1,000?
He's going to. Let me explain this way. If they came back, the taxes have not been paid.
Yes, sir.
And whether they came back or not, he now is contemplating the sale of a lien to a third party.
Yes, sir.
For the failure of the taxes to be paid. On those that he contemplates selling the tax liens, he would be, under this section, expected to do a due diligence to find out if they can locate the person, to be sure they've got the people that owe the taxes still at that address or where they are.
So, assuming that he plans on selling all of them, he's going to have to go do a due diligence on all 10,000.
Yep. No, not of all 10,000. You said he was going to sell all 10,000.
Yes, sir.
Now, he may not be selling all 10,000.
I'm just assuming that he's got 10,000 he wants.
It's the same thing every other tax office, I assume, in the state. 158 of them beyond what we have in Fulton County are doing as a way of following up to be sure they've got the people that owe the taxes coming in and paying that bill.
Yes, sir. Okay. I think I understand that.
I think you'd ask Mr. Ray, they all hopefully go through some due diligence trying to find out when somebody doesn't pay the taxes why they didn't pay it. Is that correct?
Overtime, yes.
That's right. All the time. So all we're saying, it's not overtime, excuse me. So it's not happened here, and that's what your 10% penalty helps cover too. I assume your overtime, right?
You can get it in the budget.
Yes, sir. You can get it in the budget. Yes, sir. Yes, sir. Well, go ahead.
To Representative Lindsay, the due diligence process is defined as do these actions, and this is current law. We did update it to include internet search. This is already current law.
Good point.
And it says first class mail as required by law, and if this is returned, then you have to do more. And in the 76, this is prior to the transfer, and this is only the delinquent taxes. This does not mean they have to mail to all taxes in the family. So I think it's very narrow.
Yeah.
And the last thing, Mr. Chairman, is this is already required of the transferee within 60 days of the certain of getting the transfer. So I believe what we're trying to do is just try to do
Put it before.
Give the taxpayer one last chance to take care of it.
To clear it up before it's sold.
I understand that. Thank you, Mr. Chairman.
Thank you. So we have any other comments? I want to close out the comments. This is something I think is relevant as to certainly the Fulton County property owners, because we are the ones in Fulton County, I say Fulton County being the only one that has a large sale of tax FIFAs or tax executions, and I have as a state representative heard many times, and maybe those also in Fulton County have heard many times, some complaints and problems people had with these transfers are made, not having an opportunity to know that if their bill was not paid because they moved to something, at least somebody made an effort to try and locate them if that was necessary. So I think the bill, as it stands, speaks well. I think, as pointed out, if they want to change the on line 91 and to or, that will clarify and Mr. Robinson's mind the concern we have there. We can certainly look at that being done, but we had abuses like the provision we talk about, and I call it abuse. No one else in the state has taken that 50 cents. We know that the tax commissioner of Fulton County, I think, over the last several years has received somewhere in the area of $20,000 just from the use of that provision. And no one else in the state has or would be doing it. So we're trying to take that off the books. We feel there's just some good things in here that need to be done as a part of the clearing up the problems that address, certainly in Fulton County, the tax commissioner's sale of tax liens. Any further discussion? If not, the chair is open to motions. We have a motion do pass. Do we have a second? Do we have a second? It's seconded. That Mr. Caldwell? All right. And do we have any discussion on the motion? Yes, sir. We're going. Yes, good. Chair will entertain amendments. Mr. Lindsay. All right. Any second to that motion? It's been seconded. Any discussion on the motion? All those in favor of the motion to amend signify by saying aye. Aye. Opposed, like sign. That motion carries. Any further amendments? Chair will call the main question, which is a due pass to HB 819 as amended and the committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you. Mr. Martin.
Thank you, Mr. Chairman.
We'll move on to the next bill we have is Mr. Mitchell, are you here? Come forward, please. We're on House Bill 47, HB 47.
Substitute motion. Actually, Representative Lindsay, this would be good for you.
All right, go ahead and present the bill. We really are short of time, so as quick as you can go.
Very simple proposition. Actually, this bill has been before this committee in past years. As many of you may recall, it did not receive a no vote anywhere in the process. Got caught up in the Senate Rules Committee a couple of years ago for the misunderstanding of the committee members of the rules.
Tell us what the bill does.
And the bill simply gives the consumer an absolute right to cure if they are falling behind and defaulting on their mortgage. They can come up with all the late payments and, of course, the related fees. They can, in fact, cure their mortgage and get back on track to resume normal payments. Certainly, this would put a lot of consumers in your district to
All right, we have questions, I believe, of the members. You have Mr. Caldwell.
Representative Mitchell, under current law, there is no time limit of which they can pay it. They can pay it off up to the day of the foreclosure, can't they?
No, if you have a typical mortgage, you have a contractual period in which you have to pay your mortgage. Your typical mortgage, if you have a contractual late period. After that late period
passes is strictly up to the lender as to whether they will accept your late payment as is now current law.
And one follow-up.
Yes, sir.
Under this, it says you pay all fees and expenses. What about attorney's fees? That's not in here. If you've had an attorney who had to do all the work for you in
That's
5
part of
days
the fees. That is part of the fees.
Well, it just says fees. I was concerned about that. It says and all fees.
Mm-hmm.
We normally talk about fees or something you pay anyway, but you said that's covered in this?
That is covered. In fact, as a matter of fact, when the bank has to hire an attorney to recover their losses, they do include those attorney's fees in that portion that you're expected to pay.
Thank you. Next question we have is on the end, Mr. Weldon.
Representative Mitchell, appreciate you bringing the bill. I'm concerned about the philosophy of the bill. I think that Judge Caldwell's right that someone can satisfy the debt by paying it off in full or getting another loan to pay it off in addition to the fees and expenses, all that up to the date it's foreclosed.
And that position is incorrect. As a matter of fact, what led me down this road was a consumer that I know of actually came up on the day to try to pay everything off, but had to get permission from the lender in order to do so. And the fact of the matter is, when you get behind, you have to you must receive permission from the lender to make those payments up.
That's not my understanding of the equity of redemption. That's outside the
that is indeed
the agreement.
The case.
Okay. Further, this would be modifying contracts that are in place, and this
no,
would be
it's only from the time the bill
prospectively.
That's exactly correct.
All right. Then, aren't we interfering with the right of every individual to contract as they so choose with a lender or of any type?
Well, as you may know, the lenders have agreed to this provision, and they will tell you that they don't wish to foreclose on consumers. This gives the consumers just an added opportunity to be placed in a position where they can enjoy their home.
Mr. Jacobs.
I just want to add in response to the questions that were asked. First of all, this is the language in the bill here is exactly what was worked out with the lending community. This is the bill's second trip through the Judiciary Committee. It is nothing other than what the mortgage holders and mortgage services are doing already. With regard,
the good ones, I should say, Mr. Chairman.
Pardon me?
The good lenders are doing already.
Right, but I mean, the general. This is already the general practice in foreclosure sales. In addition, it is only applicable prospectively. That's in Section 2 of the bill, and it only applies to contracts entered on or after July 2014. It does not prevent a lender from accepting a payment right up to the time of foreclosure. It's just that this statutory right only exists until 5 calendar days beforehand. So, I mean, I just want to caution members of the committee that this is, exactly the deal that was worked out previously, and we probably ought to stick with it.
Chair, I just want to remind you we're going through questioning of the presenter. You have a chance to do the discussion.
Thank you, Mr. Chairman.
Anyone else have a question of the presenter? If not, we appreciate you being here, Mr. Mitchell. Does anyone wish to speak on House Bill 47? I see no one else. We'll close off public comment at this point in time. The bill is now in the breast of the committee. Do we have discussion? Mr. Jacobs, I know you've already discussed. You got anything else you want to add to it? And all right, we are ready to proceed. Is there a motion? We have a motion to pass. It's been seconded. And do we have any proposed amendments?
I do, Mr. Chairman.
Recognize Mr. Jacobs.
This is just to clean. This was pointed out by the Legislative Council. It's just to clean up some language there on line 23. The term "good funds," although we would understand what it means, it's only used one other time throughout the entire code. Of course, we are more specific later on what good funds are. So the amendment would be to strike the words "pays in good funds" on line 23 of the bill and replace it with using one of the forms of payment set forth in subsection D of this code section, comma, pays. So it would read, using one of the forms of payment set forth in subsection D of this code section, comma, pays to the creditor or to the creditor's attorney, and continues forward.
All right. We have a motion and a second. Does everyone understand the motion? Do we need to have the motion repeated? The motion to amend. Chair will call the question on the motion to amend. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do we have any other amendments? You do? That's all right. Okay. There are no further amendments. The chair will call the main question, which is the motion do pass HB 47 as amended as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Next we have is Mr. Benton's bill.
Thank you, ladies and
Mr.
gentlemen of the
Benton.
committee. Where's the congressman? Did he leave?
This will be House Bill 133. We're working off, I believe, LC 295988S, if I'm correct.
That is correct, Mr.
All
Chairman.
right. You've got a copy. You'd like to present it to us, Mr. Benton?
Yes, sir. Thank you very much. Appreciate the committee listening to the explanation. This is a bill that passed last year, made it to rules, and got stuck there. What it would do it would allow people who have family cemeteries that are landlocked a process of being able to get to those cemeteries when the current landowner will not allow them access to the cemetery. And we have tried to make sure that private property rights are protected. We have tried to make sure that the ownership of the family members of the cemetery are allowed access to the cemetery, and would certainly appreciate the committee's favorable support on this bill.
Yes, sir. Yes, ma'am. Excuse me, Ms.
I don't remember why this didn't pass last year. It passed out of this committee.
Yes, it did. It got hung in rules, yes.
Then I'd like to make a motion, Mr. Chairman.
Appropriate time. All right. Any questions of the presenter? Have no questions. Will anyone else wish to address the committee on HB 133? If not, we will close all further public comment. Thank you, Mr. Benton.
Thank you.
Now, in the rest of the committee, do we have any motions? We have a motion. Ms. Oliver, your motion was to be recognized. Do pass. Seconded? Second. It's been seconded. Any discussion? Any amendments to the motion? There are no amendments. Chair will call the main question, which is do pass to HB 133. All in favor signify by saying aye. 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 And that's passed as a committee substitute. Thank you.
Mr. Chairman.
Kelly's. Well, he's here. Let me get who's Carson. That's the last one, isn't it? Because we did have Carson already. HB 1078, Mr. Kelly. Recognize you. You may. You certainly can. And I might add, this is a bill that has just been filed. It has some cleanup provisions to it. And I told Mr. Kelly and the prosecuting attorney's counsel that we would take this up as a means of hopefully keeping the bill moving.
Thank you, Mr. Chairman, and I appreciate you giving me a hearing on this after dropping in a little later in the session. I apologize for any request to expedite that I've made. This is a piece of legislation which is really we've heard Representative Atwood say a couple times, a companion piece of legislation that goes along with the grand jury and master jury list legislation going back to a couple years ago when we did, not me, I wasn't here, but when we passed the Jury Act. There's been a few things that need to be cleaned up here and there. So really sections 1 through 10 in this legislation do just that, where there was some concern. The code just said jurors, or would just say jurors. Sometimes we have here added just to specify that we are talking about trial or grand or other so that we could have specificity there.
What would be another, just trying to think, what other juries will we have?
I'll defer to
Mr. Chairman, if I could, Chuck Spayhouse of the Prosecuting Attorney's Council. The way we've cleaned up section 1 through 10 is basically at the suggestion of Legislative Council to make that crystal clear.
Yes.
There's been some concern that because all it's ever said is either trial or just jurors, that it did not necessarily apply to grand jury and that it needed to be clarified for the clerk.
Yeah, I understand, but we're saying trial, grand, or other jury. Now, I don't know what others would be. I'm not sure of any other jury that I've ever heard of that would be other than trial or grand jury.
And that was the language that came out of Legislative Council.
Yeah.
And,
I think sometimes there's special purpose juries, and I think that's what was.
it could be a special purpose grand jury.
All right. As an investigative type, but it's still a grand jury, but still.
Yes, sir.
Okay.
It
Well,
does have its own
I just
jurisdiction.
didn't know I missed something in all my years of trying to practice. Go ahead. Pardon the interruption.
Well, then we get into section 11, and that just really clears up that we want the presiding judge to consult with the district attorney prior to deciding how many prospective jurors that will be summoned.
Okay. And that's a good point. This is for any jury list or just the grand jury?
Yes, sir. Yes, sir, Mr. Chairman. That's for the grand jury.
If I could, Mr. Chairman, this is simply a request that the district attorney be consulted with to determine the number of grand jurors that may be needed, because the DA is the one that knows how many cases, how long they're going to take, that kind of thing. Whether or not there needs to be alternate grand jurors, that kind of thing, but it's still in the judge's
discretion.
Power. Yes, sir. It's just the grand jury.
And further?
Section 12 strikes some an obsolete provision in the code that had been around since about 1871. Section 13 makes it clear that the presiding judge and the district attorney shall have the right to question prospective grand jurors to ensure that they are statutorily qualified to serve on the grand jury. And then Section 14 amends to address another unintended consequence of the 2011 jury reforms. What happens if not enough people show up for the grand jury to make the minimum necessary to have a quorum of 16 grand jurors?
All right. Questions of the members of the committee, and I have recognized over here Mr. Weldon.
Thank you, Mr. Chairman. To Mr. Kelly and Mr. Spayhouse, on line 108 in section 11, says it reads, the presiding judge, comma, after consulting with the district attorney, shall direct. I guess there's times when the presiding judge doesn't confer with the district attorney, but it's just kind of difficult for me to imagine that situation.
Believe it or not, Mr. Weldon, it actually has occurred, and that's one of the reasons we've asked to put it in there. The district attorney is the only person that's suited to be able to explain to the judge what caseload the grand jury is going to be facing, whether or not you've got complicated cases that are going to take longer, whether or not you're going to be bringing the grand jury back in once a week or once a month. It depends on the volume of cases in the particular circuit. So all we're asking is that that be done in a style of communication so that all the information is before the judge when they make that decision.
Thank you.
Thank you.
Mr. Caldwell?
Yes, Mr. Chairman. Isn't it true, though, that a grand jury can't be made up of more than 23 grand jurors, not less than 16 or more than 23? So, and isn't it also true that what a judge is going to do, he's going to subpoena 40 to 50 to start with, and he's going to take the first 23 that's qualified. And the rest then are going to be dismissed until you need it and you send back to get for more. Is that not true?
That's the prudent way to do it. Yes, sir, I agree with that.
That's what the law says.
But
so I'm guessing, what's the need of Section 11?
you can actually, you may have the need for alternative grand jurors that are in panel that don't have the authority, but because of the duration in which they're going to serve, you have some anticipation of losing some of the original members, and at that point they would become an active member of the grand jury. That's what we anticipate.
Well, I'm not arguing, I'm trying to ask a question.
Yes,
then isn't it true that if you only can impanel 23, if you lose some of those, you just call in some more and then panel those, don't you?
Well, that's been part of the problem, is nobody's known exactly what to do after the rules changed, or whether or not you could go get them out of the regular pool or not.
I never had a problem issuing an order like that. I'm sorry to say.
Not all
right.
judges might be your caliber.
All right. Any further questions? Chair has one. Looking at the Section 12, this has been something I think been of concern. Your larger jurisdictions, for instance, Fulton, Cobb County, occasionally because of loads, there's been a overworking of the grand juries. This allows, for the first time, the actual impaneling of two separate grand juries to hear potential indictments.
Yes, sir. It actually brings it in consistency with 17755, which this General Assembly passed in 2003, that allows for the pulling of concurrent grand juries, and it's exactly that.
Okay.
It's just become impossible in the larger jurisdictions for one grand jury a term to hear all the cases.
Are there jurisdictions now doing
Fulton
concurrent?
County is a perfect example. They're running more than one grand jury at a time just to deal with the volume of cases.
Thank you, sir. Any further questions of members of the committee of the presenters? If not, is there anyone else who would care to address the committee on House Bill 1078? If not, we will close off further public input. The bill is now in the breast of the committee. Do we have any discussion? No further discussion. The chair will entertain motions.
Move to pass. Second.
It's been moved to pass and seconded. Any discussion on the motion? Any proposed amendments to the motion? There being no amendments, the chair will call the main question, which is do pass HB 1078 as presented. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. I think with that, we've concluded our business. I remind the members of the committee who are desiring to do so, we do have a dinner this evening at McKendrick's as a committee dinner. Look forward to seeing everyone there.
Yeah, that's right.
Get up and leave.